Please be seated. We are here this afternoon for the submission of 3 cases. The case versus Iowa Supreme Court Attorney Disciplinary Board versus Stephen Allison is hereby submitted without oral argument. First oral argument this afternoon is MidWestOne Bank versus Schwartz Burger, and it looks like the parties are ready. Mr. Shearer, you may begin.
Thank you, Your Honors. May it please the Court and Counsel. I'm Shawn Shearer. I represent Schwartz Burger and Shine and its 2 owners, Kevin Perez and Dan Ouverson, who are present with me here today in court. This is a case surrounding an eviction proceeding of a commercial business. Schwartz Burger and Shine has been a staple in Iowa City across the street from the Pentecrest since 2008. They operated under a term of a lease that had 3-year renewal options. The lease commenced in 2011 and was renewed in 2014, 2017, and 2017 and 2022. There's no evidence of any of those renewals being in writing. They were verbal renewals. In April of 22, during the term from April of 30 to May 1st of 2023, Schwartz temporarily closed for several reasons. One being that the retaining wall in the basement was cracking, allowing water to seep into the building, and Mr. Perez decided to close temporarily and conduct deep cleaning and renovations during his closure. On May 5th, 2022, they received a warning from the landlord saying that if they were closed more than 15 days, it would be considered an abandonment under the lease. On May 19, they delivered a letter requesting that they couldn't open because with the retaining wall, the city had come and closed down the gas supply until the wall was fixed, and that was going to take a while. They suggested that they reopen in 2 to 3 months. The landlord did not accept that and began the eviction proceedings.
On that gas being turned off, I thought I read somewhere in the record that there were 3 different gas meters attached to the same wall and the other 2 weren't disconnected. Is that correct?
I know one wasn't disconnected. It's unclear on the other one. That was the one I'm not sure about, was for the tenant that was upstairs, and they weren't operating. So I don't know if he shut that. They shut that one down as well. But I know the one for the nail salon that was next door was not cut off.
Did you ever give notice or seek permission to make these changes?
We did not make the changes. The exterior wall was the responsibility of the landlord.
The brick wall and things like that?
No, we did not, on the brick wall. It had been painted when we moved in with the clear coat, and when there were never any objections before, and that was not raised as a notice of default in the first eviction action. The first eviction action was solely based upon abandonment because of closure for more than 15 days. And that eviction action continued until March of 2023. That was March 9th, 2023 was going to be the 3rd hearing in that eviction. Half hour before, 45 minutes before that hearing was to be held, the eviction was dismissed voluntarily by the landlord with prejudice, and then an hour later, Schwartz received another letter from the landlord indicating that they had not provided a written renewal of the lease, prior to January 30 of 2023. The whole, and
I want to talk about, you've cited the Lyon versus Willie case. It's one of the main cases that you're relying on. This issue with the late notice of the option, was there any finding here that repudiation of the contract happened by the bank at any point?
the magistrate never really addressed any of the issues other than to say there's a written lease and it says in writing before January 30th, and there was no writing prior to January 30th. We disagreed with that. In September of 22, while the eviction proceeding was still ongoing, Shorts purchased insurance for the year from September of 22 to September of 23. My argument is that is a written document that's shows intent to stay past. It's from an insurance company procured by Shorts for a period extending beyond.
For insurance between Shorts and the insurance company provide notice to the landlord.
If you look at the provision in Section 8 of the lease, it says that you only have to provide a writing that shows intent to renew.
Another thing, I mean, as I read your briefing, you know, they say the lease is terminated, they file an eviction, then they dismiss it with prejudice. So you're sort of arguing that, you know, if we wanted to develop a legal characterization, what we have is kind of a repudiation of the lease because, you know, ultimately they didn't terminate, they pulled back and changed their mind, and then kind of a retraction of the repudiation. Is that, and then the issue, then my understanding of general contract law is when one party repudiates, the other party may suspend performance. This is a little different in the sense that what we're talking about is just giving a notice. Is there a practical reason why you couldn't have done more? I understand your position that this insurance thing was a notice, but is there something else you couldn't have done, just a regular notice? We're you know, we know we understand your position, the lease is over, but we intend to renew it. Is there any reason why your client couldn't, as a practical matter, couldn't have done that?
It mattered, no, but as a legal matter, it wasn't necessary on the repudiation, non-performance, and also my client attempted to pay rent for July, which was the month after the declared termination of the lease, and that was rejected. My client tried to pay rent for August, which is the second month after the end of the lease, and then we wrote a letter that said, we're willing to pay rent for each month going forward, just tell us when you want us to start paying the rent. So we were tendering payments, and there was no...
Of renewing the lease, that would, you went into a lot more effort of paying rent than just a one-liner saying we want a lease again.
I understand that, but when I'm saying that when that performance, which is required of a tenant under the lease, is being rejected, there is no reason to believe that a note that says we want to renew would be rejected also. And if you think through it, if we had sent that a notice, let's say in January, the clearest possible written notice you could before January 30th, and if the eviction proceeding was held and Shorts is evicted in March of 23, would that notice have effectively allowed Shorts to re-enter the property on May 1st, the next term for which that notice had been provided, despite having been evicted in March under the old term. And if not, then that is an illegally irrelevant act of sending that notice. It doesn't form a new contract. And if it seems that it would throw the eviction process into disarray if any tenant with a renewal provision in a lease that a landlord is trying to remove through eviction has the ability to renew, even though the landlord doesn't want them there for a variety of reasons.
Wouldn't it at least have, I mean, it would have at least shown that you did have interest in continuing with the lease, right? That would have been a clear indication.
Chris, that's correct. But also, there's also the lease modification argument that is made in the briefing in which none of the prior lease renewals were conducted in writing. They were all verbal agreements between.
That in this situation, the banker, whoever it was, testified, I did not get verbal either. Even if I was willing to accept verbal, there was no verbal here either. And if there is verbal, where is it in the record?
The testimony of Mr. Perez, and also there's evidence to support that that was the case, because during the time it was closed, Shorts was putting in $45,000 to $60,000 of renovations and new TVs, and Mr. Moat testifies that he saw all of that work ongoing, and that's not the type of capital investment someone that's planning to leave in 4 months would undertake. And
do something. So typically, I think we would say repudiation by one party excuses the other party from performance of its contractual obligations, right?
and the conditions to its obligations.
So this is kind of interesting, though, because the remedy you're asking for is really not to be excused from the lease obligations. You want the property. Your client wants the property, right?
Because as soon as they dropped the case with prejudice,
How this would work, if you would say this party is repudiating the contract, then the response would be, therefore, we are released from all further obligations, and we're going to vacate, we're not going to pay rent, et cetera. So this is kind of an odd situation where you're claiming repudiation, but then you want to enforce all of the contract except for the notice provision, right?
remedies on repudiation is that you can continue to perform and wait for the repudiating party to revoke or rescind the repudiation. I think I've gone through it. That's in the brief as well, and that's Corbin. That's been quoted by this court several times in Lyon, for example. In the Lyon case, that was one where the notice was provided, but then the landlord wouldn't accept the payment. So there were two things to undergo. But if you look at the definition of tender, it includes not just monetary performance. That is, it includes physical performance. It can include the provision of paper or anything. And so I think when we provided the insurance policy to the additional insured, indicating Shorts had coverage through December of 2023, which was after the April 30th ending term, that was an intent for Shorts to stay longer. And
Question kind of following up, I think, on Justice McDonald's issue. Were you still obligated then to follow all the requirements of the lease in your mind, except for the notice? In other words, the rent you were still obligated to give. If there'd been let's say there'd been a fire in your space, you'd probably have an obligation to tell the landlord, right? All those things would continued except this notice issue.
The third remedy would allow us to do that, still maintain the repudiation, and ask the landlord to revoke the repudiation, and we're entitled to wait for that. And then once that happens, we're entitled to go back, and if any of our performance or conditions weren't satisfied, we're entitled to cure those within a reasonable amount of time.
Didn't need to provide insurance, even if it was an obligation under the lease.
September was after we believe Mr. Perez told Kevin Moat that we were staying verbally, and just like it was before. And none of the courts below addressed the factual question of the conflicting testimony between Mr. Perez.
In the magistrate's order, page 2, 3, 4, 5, third from the bottom paragraph, that last sentence, they're talking about cross-examination. Kevin Moat testified. There's also Kevin Perez, right? He testified, so Kevin Perez testified on cross-examination, that if Kevin Moat testified that Kevin Perez never told him that Shorts wanted to renew, Kevin Moat would not be lying. Isn't that correct? I mean, that's a finding by the magistrate.
I don't believe that that's credible, given what Mr. Perez testified. I would draw the court's attention to your decision in MIMG, and then it's the Roman numeral 172. It was a CARES Act case regarding the COVID eviction proceeding, and in that you said specifically, get it to it, that Iowa Code 68.31 treats a 3-day notice as a lease term plus lease termination as equivalent of a notice to quit. And then you said a Fed action is the mechanism for getting a court to order the tenant's removal. So as a prerequisite to the Fed action, and the jurisdictional terms of Chapter 684.2 and 683.1, the magistrate didn't have jurisdiction to enact a Fed action unless the lease had been terminated and Shorts was a holdover. And for that reason, the option was terminated along with the lease, and there was nothing for Shorts to exercise. And as soon as the eviction action was dropped with prejudice, within 24 hours, a notice of reaffirmation of renewal was sent, and that was on Friday. And then on Monday, it was hand-delivered, and back rent during the time of the eviction was cured within 48 business hours. And so in order for the magistrate to have jurisdiction, the termination had to have occurred, and that obliterates the option. And when the option comes back into being on March 9th, Lyon says that there's a reasonable time to cure the condition of the option, and it relates back to as if it were given at the proper time, within the proper time. And that's exactly what this is. The option was revoked. The landlord would not accept performance. When they decided that they would accept performance and demanded back rent, the notice was provided in writing very clearly, and under Lyon, that relates back to January 30, 2023, as it was timely given.
Back, Mr. Shearer, your time is going up. So We will let Ms. Briley go.
Thank you. May it please the court, counsel. Short's arguments fail for three primary reasons. First, Short's purported notice of its intent to exercise the option to renew was fatally defective. Second, Short's fails to establish that the trust repudiated either the entire lease agreement or the option provision.
Repudiation, all right, you terminated the lease is over, you go to court to evict them, and then time passes and you dismiss with prejudice. So that sounds like a repudiation and a retraction of the repudiation. What's wrong with that analogy?
Like that, Your Honor. The problem with that analogy is that in providing the notice of termination of the lease, declaring the lease terminated, the trust was complying, specifically and completely complying with the provisions of the lease. The lease provides that if the trust is claiming that the tenant is in default, the trust is first required to give a notice of default and allow a cure period.
But the effect of the dismissal with prejudice is to say, you know, what we did before was not legally justified, therefore we're dismissing it with prejudice. So again, it seems like termination, you know, repudiating the lease, then retraction, and then we figure out, you know, what are the obligations of Shorts during that interim time period? Are they obligated to give that notice during the time period where there's a repudiation in effect?
Address the issue of dismissal with prejudice. The dismissal with prejudice does not operate as any kind of admission that the trust did not have a valid basis to bring the action.
It's a final determination of that case. And that case was brought after you had terminated the lease and said they can't be there anymore, so you dismissed with prejudice, which means, okay, no, we give up. They can be there. They just can't be there after May or whatever.
In FED proceedings, there's a limitation on whether a landlord can bring the proceeding again once the proceeding's dismissed. So a dismissal with prejudice in an FED proceeding is oftentimes much more limited than a dismissal with prejudice in another type of case. So the dismissal with prejudice of the FED petition, specifically on the grounds that Shorts defaulted under the lease, was just a statement that we know, because a specific amount of time has passed, 30 days peaceable possession, that the trust cannot bring another FED petition against Shorts on the basis of default, this particular default.
You that case the parties kept postponing the trial. You still could have tried that case, right? And if you'd won that, then there'd be no question. They can't renew, they're gone. So you chose not to do that. Instead, you, in effect, retracted the termination, right?
In effect, retracted the termination. Our view of the way that Chapter 648 works is that it's not necessarily a retraction of the statement that Shorts was in default. It's just a statement that we recognize that enough time has passed that we will not be permitted to refile this particular action. And the trust made a decision that it would, at that time, the trust's decision was it would be more expedient to proceed on the basis of the non-renewal of the lease than on the basis of the default.
Magistrate's findings too, and I remember doing FED actions. If you guys can't move on them quickly, they get stale, and different than any other action, which you might be all right with letting it idle. But an FED action idling isn't very common, is it?
And this one went on far, far longer than most. The FED statute says in the first sentence that it's a summary proceeding.
Taken it to trial and proved up the case. That would have been an option, right?
And it was in the middle of the trial that
that's right, you started the trial and you didn't finish it. So you could have continued, and then instead, you chose not to do that, and you dismissed it, and then they give, the notice the next day. It just strikes me, based on contract law, that you have a repudiation and a retraction of repudiation, and under contract law, during the period of repudiation, they're entitled to not perform themselves and to wait and see what's going to happen.
If we assume or conclude that it's a repudiation, Shorts still has a very big problem here. And that's that they sandbagged the trust. They claim that they didn't forget to provide notice. They therefore must be saying they decided not to provide notice to the trust just to see if maybe this option period would expire.
You waited, instead of finishing the trial, you waited and then turned around and said, okay, we don't need to do anything. We'll just rely on the fact they didn't give this renewal notice while the FED action was pending. The question is, I haven't found a case that's specifically on point, but why don't we apply the law that says they can suspend performance? What's wrong with applying that law?
Applying that law is that there's not any case that has, so essentially what distinguishes this case from all of the cases that apply the law of suspending performance is that here, Shorts never attempted to tender performance under the option provision, and the trust never made a clear and unequivocal statement that it would not extend the lease if Shorts tendered performance. All of the cases that Shorts relies on to establish that its performance should have been suspended and then it should have been allowed to tender notice, all have at least one of those, and many have both.
That FED action sort of say that? I mean, there were 2 filed against them. Do we need more?
Our position, and we think on the law this is correct, that because the trust fully complied with the terms of the lease in providing the notice of default, allowing the period of, for Shorts to cure, Shorts didn't cure, Shorts took no action to attempt to resolve the default, the trust was entitled, under the terms of the lease, to then declare the lease terminated.
This isn't a repudiation in contract terms. You're actually enforcing, it's a remedy issue under the lease. You're just enforcing the lease terms as you're allowed to by law, not repudiating the contract.
In this circumstance, because the trust complied with all of the provisions in the lease.
Provision of accepting rent. You refused to accept their rent when they were tendering rent. Why is that not a separate repudiation if you are not treating the lease as having been terminated?
Concerned because of the FED statute that if the trust accepted rent, then it would be creating a new tenancy. The lease has a term for a holdover tenant.
You want to pretend like the FED didn't happen and the bank was doing everything that they were entitled to and supposed to be doing under the lease, but that doesn't seem to be true if you take into account the fact that you were in the middle of an FED proceeding.
Respectfully, Your Honor, we would disagree that the trust was not doing everything, that with your statement that the trust was not.
FED action. Suppose you had just sent the notice, we terminate the lease because of X, Y, and Z. And then later on, you did what in effect you did and say, we changed our mind, we are not terminating the lease, whenever that date was that you dismissed with prejudice. What's the difference? And that would clearly be a repudiation and a retraction of repudiation.
Well, the difference would be that because the notice of termination was given pursuant to a specific set of circumstances that the lease required, if the trust then did not follow through with that, that notice of termination would have no effect. Saying we are going to terminate, and let me back up for just 1 second on the FED stuff, because I think this is a very important aspect of this case. FED cases require a judicial determination before a tenant can be removed. So it's not, the effect of what the landlord does to get to the point where the court says, okay, landlord, you've proved everything that you need to prove, and we will support you evicting this tenant. Here's the, writ of possession and removal. Unless you have that, everything that came before it essentially evaporates. If the court says you can't,
Notice and the tenant just leaves, right? Yeah, so I mean, the point is that, if we just view it, like I said, take my hypothetical, if you given the notice and then later on you said, no, we changed our mind, what's the difference? Yeah, you went through the judicial process, but why should that change anything?
and I think the primary reason why it's different is that the trust had no obligation under the option provision unless and until Shorts tendered notice of its intent to exercise the provision. The trust there was no obligation until it received notice that Shorts was exercising its option to renew.
Well, for the tenant to think that giving that written notice of renewal would be a futile act while an FED action to evict them was pending?
I believe it's reasonable for the tenant to conclude that, and especially when you're dealing with a sophisticated commercial tenant that has provided notice to renew more than one time in the past. This tenant knew what was required to extend the lease under the terms of the lease, and this tenant made a determination that we're not going to do that because maybe we can back them into a corner and make an argument after the fact that they deprived us of something that they didn't intend to deprive us of. So I think they're reading a lot into the trust's actions to proceed with this particular eviction.
Insurance renewal effective as a notice of renewal of the lease?
That can't, our position is, and we think this is the better position, it cannot be effective as a renewal of the lease because, for one,
To be a renewal of the lease, it just needs to be a notice of intent of renewal, right?
but our position is it can't comply with the provision that they provide notice of intent to renew. I'm sorry?
Copy of it as the additional insured?
And I don't know that we have any testimony to that fact, but it's customary for the tenant to provide it to the landlord.
Than I do. Did the lease require them to have insurance? So they're trying to double dip on that. They were already required to do that. I'm not as persuaded as maybe my colleague is here that there's a problem with the dismissal. I'm imagining clients, I had many clients who funds were not easy to come by. And if I was pursuing an action for them and all of a sudden I had a clear-cut path to achieve the same thing, quick and easy, I'd probably ditch the one that's been going on for third day of trial as well. Was there, if you would have wanted to dismiss without prejudice, that would have probably involved the other side's involvement. I don't know if he would have been successful. But my main question is that I don't agree with what his questions are regarding that it meant that you didn't have a solid case. I think it just is efficiency, representing your client, saving money, whatever. But why didn't you just let him hang?
Well, to address the dismissal without prejudice, we didn't have that option. We could have said that, but the effect would have been the same as a dismissal with prejudice because of the 30-day peaceable possession rule. They would have gone more than 30 days, having been in default. We wouldn't have been able to bring that cause of action again anyway. And under the FED statute and the lease, we could not give them a second notice of termination once we already started a Fed proceeding. So that had to be dismissed in order to give them the notice.
Regular case, if you're in the middle of trial and you said, Judge, I'd like to dismiss my case without prejudice, I don't think the judge would have gone along with that.
You know, I
Dismiss it, but it's going to be with prejudice. We're in the middle of trial.
True, and that's not exactly how it happened. I had a conversation with Short's counsel that morning, and we discussed the next steps. And Short's was represented by different counsel at that time, but I conveyed to him that this was how we were intending to proceed, and he said okay. And so he was aware that we were going to take this different course of action to move the case in a different direction, which we thought was going to be more efficient. And there was a question I wanted to.
for you. So if you had not dismissed the FED, and if Shorts had given the notice earlier that they intended to renew, you continued with the FED, and then you're successful in getting the lease terminated, would Shorts have had at least been under the risk of then you saying, oh, you owe us 3 more years worth of rent?
Because this was not a separate contract. The option provision was the right to renew the lease. If the lease was declared, if the court agreed with us that the lease had been terminated and Short should be evicted, then all of the provisions of the lease would go away and they would not have that option to extend it. And
If we are persuaded that there has been repudiation by your client, what do we do? Does that necessarily mean reverse? Where do we go from there? If we say there's repudiation, then what?
well, Shorts is asking for, essentially asking the court to treat it equitably based on this purported repudiation. And it is our position that Shorts had a duty to exercise the option or to provide notice of its intent to exercise the option within the option period. And it did not do that. It, according to Shorts, did not do that deliberately. It hid the ball from the trust. And it is our position that because of that, Shorts is not entitled to the benefit of equity.
Their motive to hide the ball, to play it that way, what would they gain?
I actually don't know the answer to that, Your Honor. It is my position that, you know, I have a suspicion that they may have forgotten, but we don't have any facts that support that. And their statement is they did not forget. So all we can do is conclude that they deliberately chose not to take any steps to preserve their right to renew if, in fact, we didn't succeed in Fed number 1. And they were required to do that. They didn't give us any notice that they believed that by following the terms of the lease, we were breaching the lease. So, unless anyone has questions. Okay, thank you.
And while you're walking, it does seem to me like you're trying to play both sides. The lease is in place. It's still active. It's a live wire. Here's your rent. Here's your rent. Here's your rent, even if they won't take it. But then you ignore the renewal. It's either in action or it's not. Help me understand that inconsistency.
The time that they were not accepting the rent, then they were not performing their obligations under the lease. I mean, their obligations were provide possession and provide quiet enjoyment and to accept our rent. And they were doing none of those things. And under those conditions, sending a notice of renewal seems like it's going to be a futile act. And I think we just heard that that act would be futile.
Over and over and over and over, eventually in your mind, perhaps maybe futile, and yet a one-liner. I just don't buy that argument. Help me understand.
Twice, and then wrote a letter that said, we'll pay the rent, tell us when you want it, and we never got anything in return.
You didn't pay rent, you didn't attempt to pay rent every single month. You did it for a couple of months and then you stopped with that letter.
Rent, tell us when you want it.
Was that before or after the option renewal ran?
Tried to pay July, August, and then wrote that letter for September. So it was September, October, November, December, January, February to March 9th. And we never got a notice that they wanted rent paid other than those first 2 attempts.
You have renewed the lease. How early could you have given notice of renewal?
Anytime prior to 90 days. Yeah, and it's so, but that hasn't historically been the practice. It's always been, December, January, near the end of the lease,
Ending these efforts to pay rent, would that have been a good time?
Well, this would have been July of 22 when the eviction proceeding first started, there was no, there were 10 months remaining, and
Your clients intended to stay, right?
I did intend to stay. The concern being that we were signing up for another 3 years of damages in the event that the eviction, and we lost the eviction, and them trying to say it's not just missing rent from July through April, it's now missing rent July through April and another 3 years under the renewal term. And and that's a risk that we didn't think that
That there was an intentional choice not to renew?
until September when we bought the new insurance policy. We thought that this eviction proceeding was extremely long, lasting from July through March of the following year. And normally we would have had a decision on whether we were evicted or not much earlier. And the first hearing, I believe, was in September, and then one in January or December or January, and then January got postponed to March, and it just was dragging on and dragging on. We thought we'd have a decision on March 9th, and then right before the hearing, Ms. Briley spoke with former counsel and informed her that they were going to drop it with prejudice. And then that's when we sent them to note that it was renewed. I wanted to address a couple of things. We really didn't get to the equitable concerns, but I read about unclean hands, and I think the games that were being played, this sudden dismissal of a 9-month eviction action with prejudice, and dropping the second eviction action. They say without prejudice, but it was dropped the day of the trial, which would make it under the rules with prejudice itself. And there's also equitable estoppel. And I would cite to Dart v. Thomas, it's 261 Iowa 237, in which fraudulent intent is not essential. If fraudulent effect would follow allowing a party to set up a claim inconsistent with its former declarations or conduct can be stopped equitably, and given this is an equitable proceeding, the games that they pulled on March 9th, dismissing this with prejudice should place Shorts back in the position it would have been with an option that had been taken away from it, and that should relate back as in the Lyon case.
Question. If you guys are arguing equitably, we gave all kinds of indicators we were going to renew the lease. We got insurance, which we were supposed to do anyway. We attempted to pay rent, which you never took. If you were so sure that those are indicators of renewal of rent, why did you within 48 hours immediately send a letter and then do an email and all kinds of, quote, notice? If you already had notice, why'd you do that? It looks to me like you hadn't and you forgot. Let's hurry up and do it.
Say it was forgot. I think it was designed to address the fact that we thought that Shorts thought that they weren't going to be around anymore and didn't want to be have another 3-year term where they couldn't occupy. So it wasn't forgetful. It wasn't negligence. It was with the advice of counsel, and I think that is.
That I don't get that either because, all right, you're arguing that it counted, then you would be on the hook. You're saying you gave notice, and the reason you didn't give written notice is because you didn't want to be on the hook, but you're saying you gave notice. Wouldn't you have been on the hook if you consider that to be valid notice?
I think it's a futile act that the law doesn't require. I mean, once the eviction action is started, and all of the repudiation remedies, including not needing to perform at our election, I mean, it becomes our election whether we want to perform after repudiation. And it's our election that we can wait until the repudiation is rescinded and then perform the obligations and conditions under the repudiated contract that we didn't perform, and those that we get a reasonable time to do that, and it's treated as if it occurred when it should have.
And that before that time you had not?
I think it was repeated. I mean, we performed some, tried to perform some of our obligations. We tried to perform, pay rent. We weren't required to if the contract was repudiated. We didn't send the letter because we didn't know the outcome of the Fed action. And as soon as we knew that outcome, we had a reasonable time to exercise the option, and it would relate back to the date of January 30th as if it was performed in accordance with the agreement, and that's the lying case.
Of MidWestOne versus Shorts Burgers is hereby submitted, and we'll have a brief pause while the next council prepare for State versus, I'm not sure if I'm pronouncing it correctly, but Schadl. Wilson, how is that last name pronounced? Okay, thank you. Looks like the parties are ready and the court is ready. We are now here for the oral argument of the case of State versus Schadl. And it's my understanding Mr. Koff will be arguing for the appellant. Thank you.
May it please the court, counsel. My name is Kyle Koff, and I'm a law student intern representing Mr. Schadl in this oral argument. Before I begin, you'll notice that I have a stutter. I've stuttered my entire life, and it's not because I'm nervous. Please let me know if you would like me to repeat anything during the argument. The basis of this appeal is the district court's denial of the motion to dismiss the charge against Mr. Schadl under Iowa Code Section 724.26 sub 2 sub A, possession of a firearm by a domestic abuse offender. Before I discuss the legal arguments, I want to emphasize two key facts. Number one is that Mr. Schadl's original conviction for domestic abuse was almost a decade and a half ago, 14 years. By now, he has completed his original sentence. And two is that in that time frame, again, almost a decade and a half, he has no convictions for crimes of violence. The two issues on appeal are if the charge against him.
Moment. How old was he 14 years ago, just about? Was he a youth? Was he a juvenile?
Your Honor, I can't give an answer on that. I appreciate it. The two issues on appeal are if the charges against him is inconsistent with the Second Amendment of the United States Constitution and Article 1, Section 1 of the Iowa Constitution. I'll begin by discussing the potential processes on paper available to Mr. Schadl to potentially possess guns again. I will then discuss the Second Amendment claim and then the Iowa constitutional claim. Starting out, on paper, there are 3 ways Mr. Schadl could potentially possess firearms again. But 1, expungement is not an option under state law for domestic abuse offenders. 2, restoration is not an option because the governor cannot restore rights which are also denied under federal law. And 3, the only option is the state pardon process, which in this context, defense argues is not constitutionally sufficient.
Correct me if I'm wrong. I thought there was a process that he could initiate under federal law to remove the federal disability that attaches to his domestic abuse conviction. And I understand that there was not funding being provided for that program for a long period of time, but now funding has been restored. So isn't there, at least at step 1, he could remove the federal disability, and then that might make it possible for him to remove the state disability. Is that wrong?
Even if that is correct, Your Honor, the issue here is the charge under state law. I don't believe, and please correct me if I'm mistaken, I don't believe the federal process would necessarily remove the state disability.
Intertwined in this sense. So if we agree that federal statutes trump the state constitutional right, do you agree with that? So under federal law, he has a federal firearms disability pursuant to this domestic abuse conviction. So he has no right to possess a firearm as far as the federal government concerns, which precludes his state right to possess a firearm. So he doesn't have a right as of right now, isn't that right?
Under the federal statutory scheme, that is correct, but I want to emphasize that the charge here is under state law. So I take it that your concern is a supremacy clause issue. And
well, it's more of a, does he even have a state constitutional right under 1A if federal law precludes him from possessing a firearm at all? I mean, he can't have a state right to possess a gun that trumps the federal firearms disability.
I think the solution to that concern is still the distinction between it being a state charge against him and the federal charge against him. There isn't one. This court has the duty to hold if the state statutes, both on its face and as applied to Mr. Schadl, is constitutional. That would include under state law and it would include under the state constitution.
So you're saying, are you saying it's because it's a state criminal statute, the state can't criminalize something that would be unconstitutional under Iowa law, even if it would be constitutional under federal law? Is that, yeah.
Under federal law, but disallowed under the federal statutory scheme. And stepping back to why the pardon process itself is constitutionally insufficient in this context, the United States Supreme Court emphasized in Rahimi that the government may temporarily disarm individuals who are a credible threat to others. Under state law, the governor has absolute discretion to grant or to deny a pardon. The process is not based on dangerousness. The only standard is the go.
It's been more than 10 years, as you mentioned. Has Mr. Schadl at least tried the pardon process?
The defense's argument is that he should not be required to go through a constitutionally insufficient process to ask for his constitutional rights back.
Discretionary part of that makes it unconstitutional, or the timing?
Discretionary part, put simply, a criminal defendant could have undisputed evidence that they are no longer they are no longer a danger, and the governor would still have absolute discretion to deny the pardon, even in that case where the defendant has that undisputed evidence that they aren't a danger.
Client's challenge here facial and as applied, both?
Yes. Your Honor.
The as applied challenge, what are the facts that your client points to as specific to him of why this is a problem?
The central issue is that because there isn't a constitutionally sufficient process to determine if he is dangerous or not at this time, as would be required under AMI, that the state statutory disarmament of him is indefinite, and that is constitutionally impermissible under the history and tradition test.
A facial challenge? I mean, there's nothing about Mr. Schadl that we're learning about. That's just about the statute generally operating.
Part as applied to him is the fact that is the time frame as well since he has become, or since he was convicted of the original domestic abuse offense. I think that would contrast this case with State v. Kiefer, in which the defendant, well, a couple ways, but the one here would be the time frame between the domestic abuse offense and the constitutional challenge to disarmament. In Kiefer, the defendant, after conviction, challenged the notice immediately. Here it's been almost a decade and a half, and in that time frame, he has committed no crimes of violence. So here, as applied to Mr. Schadl, he is not a threat to others at this time, and given that he has no constitutionally sufficient process to argue that because he is in a danger, that he should be able to possess firearms.
Statistical evidence in social science that domestic abusers are recidivists, or many of them are.
One is that would apply on the state constitutional claim, so I want to start by distinguishing that from the federal claim. And two, the defense's argument is that that isn't a proper strict scrutiny tailoring analysis. It's closer to this law is connected to or is related to the state's compelling interest. Well, the key fact I want to emphasize is that the state's compelling interest in keeping people safe only applies to only is achieved by disarming dangerous individuals. I think it is because of the length of time Mr. Schadl has been non-violent, and since that conviction, the fact that he has no means to prove he is no longer a danger indicates that a less restrictive alternative under that.
Here, the state points to a bunch of data that shows that there's trouble for a good long while, at least in terms of domestic abuse convicts. And so here, what data or what do you point to that would show that 14 years is too long, maybe 5 years is too long? What's that time period?
It isn't just the time period, Honor. I think it is the lack of individualized process also, because even if statistically there is a long time period in general for domestic abuse offenders, there's still going to be individuals like Mr. Schadl here who don't fall in line with those statistics. And because the test here is a strict scrutiny analysis, this court must determine if the law is narrowly tailored, and because it doesn't allow that individualized process.
Would it be unreasonable for us to say that we really can't make an evaluation of your argument and say there's an insufficient individual analysis, unless and until you've gone through the pardon process, at least tried that.
Issue with that, to respectfully push back, the pardon process isn't an individualized determination of dangerousness. As I think the simple way to put that is that a defendant, again, could have overwhelming and undisputed evidence that they aren't a danger, and the governor would still have absolute discretion to say you don't get a pardon. I think that's because the pardon process is aimed at the conviction as a whole, isn't focused on the right to possess firearms. So the fact that that Mr. Schadl has not gone through that process isn't constitutionally relevant because it's a constitutionally insufficient process.
Constitution is sort of strange. As I read the federal Constitution, the president has all the pardon power. That's completely vested in the president. Here it says, in our Constitution, the governor shall have power to grant reprieves, commutations, and pardons after conviction for all offenses, subject to such regulations as may be provided by law. And then there are some statutes which you correctly state don't regulate the reasons. But what if we said, you know, our constitutional remedy is for Mr. Schadl and other similarly situated people to go through a pardon evaluation through the Board of Paroles, you know, as provided by the law, which we're giving in this case, and then for the governor to determine. Governor doesn't have to pardon the offense, but would have to determine whether it's suitable to restore gun ownership rights. Why wouldn't that be a potential remedy?
The dangerousness or potential lack thereof wouldn't be the determinative factor in that potential process. Of course, after this case, if this court agrees with the defendant, the legislature could come back and create that type of process, indicating that dangerousness is the linchpin of the analysis in that restoration or in that pardon process, but that isn't the case here, and because that isn't the case here, the statute is unconstitutional.
Article 1A prohibits categorical determinations of dangerousness by the legislature.
I think Article 1, Section 1 potentially would, and I think in certain context, the federal Second Amendment potentially would.
So if the legislature were to say, for example, people who have been convicted of attempted homicide using a firearm cannot possess a weapon, is that a constitutional problem?
Then my time has expired. Is it okay if I answer the question, Honor? Yes. So under state law, I think there could potentially be an issue narrow tailoring. Under the federal Second Amendment, the historical analysis becomes a bit more nuanced. And I think the key issue there is that historically there wasn't a category of people who were arrested for domestic abuse offenses, because at that time, domestic abuse wasn't a discrete individual crime, which is why historically legislatures responded with surety laws, which were temporally constrained and allowed for an individualized appeal.
Thank you, Madam Chief Justice, and may it please the court, counsel. Good afternoon. It's a privilege to be here. The district court's ruling should be affirmed because a law that disarms a group of people whom the legislature believes to be dangerous as established by their membership in a group or their prior violent behavior is consistent with the history and tradition of firearm regulations and passes the Bruin test. It also is narrowly tailored, this law is narrowly tailored to serve a compelling government interest in preventing intimate partner homicide and other acts of firearm-related violence by those previously convicted of domestic abuse offenses, who the data has shown, as you pointed out, and as your concurrence in Cole points out, Your Honor, have a much higher recidivism rate and are likely to reoffend. And those reoffenses are extremely likely to become fatal if there are guns present.
Counsel, just so we can kind of compare fundamental rights and how we treat them. With domestic abusers, the state in this instance is taking the approach of making them less dangerous by removing the firearm right. Could the state also remove the right of domestic abusers to live in domestic situations and thereby avoiding future domestic violence in that way? And could there be a lifetime ban on that? Would that be constitutional?
So the analysis would be different. You would have to do a due process style. There'd be First Amendment implications of freedom of association as well. Due process, you'd be talking about. Now, the reason I'm saying the analysis would be different is that the analysis is always contingent on the right that's being asserted. And I bet that wouldn't survive. But I do think it's worth pointing out that the route that the state has chosen to pursue is not that more burdensome one. The only burden on the life of the person previously convicted of domestic abuse offenses it's not on the relationship itself. The state doesn't insert itself into those future relationships. It just says no firearms may be present in the event something does occur down the road.
Let me ask about this sort of, the Second Amendment, the Bruin-Rahimi analysis, where we look for sort of historical analogs. There's sort of two sets of kind of folks that are disarmed. There was, as I understand it, they're the temporary disarmament, the going armed laws, the surety laws. If you're a drunkard, you can't have we can take away your firearm. There's the temporary ones. Then there are these permanent bans to Native Americans, blacks, Catholics, and all that. It seems to me that you're trying to rely on the latter, and I have to say that kind of leaves me cold. I mean, we're going to wait and see what the U.S. Supreme Court says, but it leaves me cold because those were not bans that had anything to do with anything that those people did as individuals. They were just disfavored groups. I mean, that would be like saying today, because in colonial times, women didn't have full property rights, which they didn't, we don't have to give full property rights to people that, we think are not capable of managing their property or something like that. And that just analogies just leaves me cold. So help me, if we have to rely on that other group of laws, doesn't there have to be an escape hatch?
I agree that the surety and the going armed laws those did have escape hatches. They did have some temporal limitation or opportunity for review. The second category that you're talking about, which also includes tramps, in some states, people of mixed race, loyalists, Catholics, freed slaves, those don't, right? And obviously, I'm not endorsing those as good policy or morally defensible. What Bruin instructs us to do is to look backward at the how and the why. If you look too closely at the why and say, Bruin doesn't stand for you can have firearm regulations that target those disfavored groups. You have to zoom out a little bit more on the why and say, the why is because those groups were considered by the legislature to be dangerous. Bruin expressly disclaims any reviewing of the fit between, how well the measure achieves that.
To make themselves dangerous. If you're talking about people that are classified based on something they had done personally, then we're in the temporary laws, right?
We've got the tramps, the homeless beggars who are living a certain lifestyle. We've got the loyalists, those who slandered, libeled, defamed the resolution. You've got the Catholics. I think religion is a choice, but you could view that either way. Now, I don't want to get too far in the weeds on that, really, because Bruin is not a historical straitjacket, right? And the point that I really want to make is that look at the how. This is a class-based, category-wide disarmament. To say that because those laws are distasteful, they don't establish a historical tradition of class-wide disarmament of people considered dangerous, just be willfully misreading the historical record. It's like saying, it's like saying that dentists historically have frequently drilled the wrong tooth. Therefore, the historical record establishes that dentists don't use drills.
Could the state literally choose dentists as the next group that it decides can have no firearm rights? I mean, is it just any group that the state decides shouldn't have them?
You know, I do think the Second Amendment would permit that, actually. I think that because what the Second Amendment is specifically doing after Bruin is a value-neutral analysis of whether historically similar methods of firearm regulation were permissible, which they were, and firearm regulation to achieve a not historical twin, but historically relevantly similar end, protecting the public from a group perceived to be dangerous. So, I mean, I do think those dentists would have a remedy. It just wouldn't lie in the Second Amendment, similar to the way that, you know, when the black codes fell, it wasn't the Second Amendment that brought them down. When, you know, the Second Amendment was not understood, and the state analogs before incorporation, obviously, were not understood to prohibit these kinds of exercises of legislative power to disarm groups of people considered to be dangerous. And that's why you won't find a single circuit court that has struck down 922 G1 or G9, despite the fact that those don't really have a, you know, there exists, and now maybe it's funded, but the existence of that remedy, the opportunity to prove one's non-dangerousness, is not essential to establish the constitutionality under the Second Amendment of those more permanent disarmament regimes.
1A, though?
Well, 1A is a different question. And I think it's important that we're bringing up the statistics and the science and the evidence. Now, I have seen no evidence about desistance of the recidivism rate for domestic abuse offenders.
I'll be there quick. Who has the burden under 1A? Where does it start? Does it start with the state because it's strict scrutiny?
So ordinarily, the party attempting to establish the unconstitutionality of a statute bears the burden. And I think that's the appropriate place to start. Now, I do recognize that you're right, that when courts apply strict scrutiny, they frequently say that the government has the burden to establish compelling interest, narrow tailoring. But that doesn't subvert the more generalized burden of the challenger to a statute that we presume statutes are constitutional.
Start with you and then flip?
I think that's one way to envision it, that the flip happens when the state establishes the applicability of the law to the offender and the conduct.
I mean, Bruin kind of does it backwards, right? From that. Under the first prong, defendant shows Second Amendment applies, then it flips to the state. Wouldn't it start with the state to have to show that it passes strict scrutiny? I mean, at least initially?
So I think that it's an interesting question because it has those two competing lines of our case law, and the implication of it would be that every time a person is prosecuted for violating one of Iowa's gun laws, that then, you know, the whole legislative subcommittee that passed that law has to appear in the district court to make an evidentiary record. And I don't think that that's what was envisioned with Article 1, Section 1A. I do think, now at this point, the burden question is kind of falls out, right? Because at this point, this court is reviewing the constitutionality of the law to see if it passes strict scrutiny, and I'm not sure how the question of burden really enters into it.
I mean, first of all, this question was just answered in NS, right? We just said, under strict scrutiny, it's the state's burden to show 72431, and then it serves a compelling state interest and is the least restrictive means of attaining that interest. Now, if we stand by that, then the next topic is sort of how you fulfill that on behalf of the state, right?
So, but then INRI NS says it's constitutional to shift that burden to the petitioner in that context. And I think the context of a criminal prosecution is another one of those where, you know, this court can be the final arbiter of constitutionality, but
about how a statute works. That's not about the constitutional burden of least restrictiveness. And so I want to know, I guess my question is sort of how you address that. I'll go along with you on a compelling state interest to protect against domestic violence, 100%. What I'm struggling with is how you've shown that it's the least restrictive means of attaining that interest. I mean, is a lifetime ban just the best we can do, and will it apply in every single time that there's a compelling state interest?
Individualized assessment does not qualify as a least restrictive means that achieves the interest is because nobody can predict with certainty which offenders of that high likelihood to recidivate group will be the ones who actually do recidivate. Yes, it's...
The process that we followed in NS for the mental disorder process?
Don't think that that's constitutionally required, and the reason is because of, I think that the statistical evidence marshaled in our brief, marshaled in the concurrence in Cole, in Scowen, and in other cases to consider this, including Boyd from the Third Circuit, establishes pretty compellingly that the recidivism rate is high enough that, it's so much higher than the baseline that it warrants a presumption of not only potential to recidivate, but also an inability for us to identify through an individualized analysis who, which of these squares is the mine and which one is safe. Now, I think that your question about going forward for lifetime is an interesting one. Now, I'll remind you that I still haven't seen, hasn't been provided, and I haven't found any statistics on lifetime desistance of domestic abuse offenders, to weigh against the longitudinal studies on recidivism that I have seen and I've cited for you. But
do any of your studies that you've looked at identify, like, if someone goes 15 years without any kind of evidence of any kind of domestic violence, whether or not the recidivism rate goes up or down? I mean, the longer they go, is there evidence that shows that the longer you go, the less likely?
I'm not aware of studies that specifically break out the longer tail. Usually they say, we surveyed over this period, here's the recidivism rate. So I'm not aware of any studies that do that. I do know that the studies that looked at a 10-year recidivism rate found a significantly higher rate than the ones that looked at a 5-year recidivism rate, if I'm remembering that correctly. But I want to point out that, like, the thing about domestic abuse in particular is the way that it transgresses our expectation of loving, gentle treatment of those you are closest to, and subverts that in a way that shows a capacity for intimate partner violence that for many people is unthinkable, a thing that is not within your capacity to do or even to contemplate doing. And once you have established that through your conduct and a court has found beyond a reasonable doubt that you committed that act or you have admitted to it in a binding voluntary guilty plea, that establishes something about the person that the state cannot in good conscience ignore going forward.
Individualized analysis of the particular record for the violence? I mean, does it make a difference whether it was relatively minor, somebody got scratched, pushing back and forth, versus some of the horrible extremes? Does that play at all into the analysis?
I mean, you could conceive of that kind of a searching analysis that could be done if the requirement was that this be perfectly tailored, but it's not. The requirement is that it be narrowly tailored, and this state, this draws a lot narrower lines than ordinary felon in possession statutes do. It specifically only applies to offenses that transgress, that establish that potentially dangerous and high recidivism conduct. Now, I also think that even if you thought permanent disarmament couldn't survive strict scrutiny, and I think it can, the availability of a pardon or restoration procedure helps establish that this is more narrowly tailored than what you're describing.
Preemption issue. We touched upon it in Kiefer, where I think we said we couldn't reach the Article 1, Section 1A issue because of the Second Amendment, or the federal kind of disarmament provision. And it seems hard, for me at least, to say, well, there's a state constitutional right to possess a firearm when federal law, I mean, I guess in theory, like, there is a state constitutional right, but under this particular circumstance, this gentleman has been divested of the right by federal law. Can you address that issue?
Madam Chief Justice, I see my time's expired, if you'll permit me. Thank you. So I think that if he were looking for a declaratory judgment about or restoration of a right or something like that, I would say that I agree with you that there's no state constitutional issue. Here, the power of the state is being used to prosecute for a violation of a state. So I tend to think that it's possible for the state constitution to prohibit this, this restriction on the right to bear arms, even if he would. Now, I take your point that federally, right, he doesn't actually have a right to bear arms because he experiences a different disability of it. So I understand that point, and I think it's a good one.
Issue of his legal right, but as a matter of fact, in the United States of America, as of right now, he has no right to have a firearm pursuant to federal law, period. I mean, as a factual matter, right?
I agree with that. And so I think that, I tend to agree with that. I think that the real fighting issue here, and if the Second Amendment challenge were, if there were meaningful division within the circuit courts about that challenge to 922 G9, I think that would be a harder call to make. But specifically as applied to the Second Amendment challenge, courts generally have come out in favor of finding that this fits very easily within a historical tradition of firearm regulation.
Thank you.
I want to start out by briefly discussing the Supremacy Clause issue and the nature of defendant's argument here. Defendant's argument isn't just that categorical disarmament is unconstitutional, either at the state level or really, it's that categorical permanent disarmament is unconstitutional. And I think a similar challenge could be made to federal law, but here the state's police power is being applied in a way that is unconstitutional under state law or a state statute that's unconstitutional under either the state constitution or the federal constitution. So I think that does get around the Supremacy Clause concerns. And I want to start by briefly discussing the less restrictive alternatives that Honor asked opposing counsel about. The legislature has all types of processes for risk assessments, investigations, in the mental health process in the interest of NS. It just so happens that the only place they don't have that, or one big place they don't have that process, is when strict scrutiny applies. And that is an issue because strict scrutiny applies here. The legislature could enact some other process as it has in those other situations to make the law sufficiently tailored, but that isn't the case here.
With sexually violent predator law, there is a requirement that the state can be required to make continued showings while they detain someone. They're taking away their constitutional rights because their criminal sentence has expired and you're continuing to hold them. And so they have to make an ongoing showing. Is that the sort of thing you're saying could apply here?
Potential less restrictive alternative, and basically that would be up to the legislature after this case potentially. But the key point here is that because there isn't any, because those less restrictive alternatives exist but aren't in effect here, that the statute fails scrutiny. Also,
Opposing counsel's point that these are domestic abusers, and so it's that in that context and with such a high recidivism rate, according to the studies, that in that kind of environment, that we just can't expect or we shouldn't have to require an individualized assessment because the recidivism rates are so high, and so we can't make that independent or individualized judgment with respect to an individual.
That recidivism rates are high does not conclude that it's impossible to make it individualized as
With the fact that it's in the context of a domestic relationship.
I think we do have those processes in place for similar situations. For example, as Justice Mansfield pointed out, in case of sexually violent crimes, that could still potentially be a domestic situation, and we have those processes in place there, but not here, even though strict scrutiny applies here. And I want to conclude by discussing the historical analysis under the Bruin and Rahimi test. I think the case out of the Kansas Supreme Court, United States v. Curiae, which is in the state's additional authorities, is instructive on this. The court emphasized that the why of the law, comparing it the temporally constrained Kansas state law, was preventing violence through temporary disarmament, and the how was a narrow and temporary burden. A key idea from Rahimi is that if the statute here is more restrictive than the historical statute, which here is the Schadl laws, that's an indication that the current statute here is unconstitutional. This court emphasized the importance of being temporary in interest of NS, and the Supreme Court did so in Rahimi also. I ask this court to grant the motion to dismiss.
Today as well. The case of State versus Schadl is hereby submitted, and the court will be adjourned for the day.